Hey everybody, John Greenwald here with theblackvault.com. Forgive my nasally voice. This time of year, it gets me every time here in California. I'm recovering from a cold, thankfully not COVID related, but I apologize for the horrific voice that I've got right now. I'm going to try and stay somewhat clear throughout with you guys, but I wanted to bring this story with you without a delay. I'm going to be upfront and honest with you guys. It's frustrating. I will say it's very frustrating, and it, in my mind, is kind of a blow to the transparency efforts that we all want to see underway by the U.S. government on the UFO issue. I'm going to do this in two parts. I'm going to give you the story up front in a nutshell. That way, for those who don't like all of the details that go along with these videos, you can get it up front and you don't have to listen to the back end, which is going to be a little bit more of a breakdown of the FOIA response letter. Now, to properly set up this story, this stems from another video that I did not long ago on this channel, and it was all about a story that actually got some worldwide attention when I had published this. In essence, the U.S. Navy had denied me any UFO or UAP video under national security. They said, and I'm paraphrasing through FOIA, that what I had requested, which was any UFO video with that UAP designator or UFO designator, any of them, I requested all, but any that were releasable, they said 100% of them were not. Now, the video I put up was an appeal to that. Now, through FOIA, your next step, if you're denied something, is you appeal. The third step is a judicial review. You go before a judge. We'll deal with that later. But this step was the appeal. I did a full breakdown, which I don't normally do, but I wanted to show you all a little bit about how that process works. It was a very detailed appeal, but I also wanted to show the general public why I felt those videos should be released. As of today, about an hour ago, the appeal was denied. After going through all of that extensive detail about how I felt that videos could be released either in full or in part, namely because the other three FLIR, Gimbal, and Go Fast UAP videos were released, I tried to put up an argument through legal means to get those videos released. I tried to get that decision reversed. They refused. Now, why do I think that this is such a big deal? Some of you may go, wow, that doesn't really sound that big of a deal. They're very secretive. What this essentially does is solidifies the secrecy that they now have encapsulated anything related to UFOs and UAP in. Specifically, it's the most important part of these phenomena, the visual imagery. In this specific case, it was only videos. I tried to separate videos and photos. I do have a separate case for photos. We'll see how that turns out. I'm guessing it's going to be the same thing, but who knows? I'm going to put up the same fight because it's a little bit different when it comes to photos. But again, that's something I'll save for another day. But this specific case was only for videos, and what this essentially does is shuts out us, the general public, seeing anything. Now, FOIA officers can often just, make a decision and say, well, this is classified. They go through a review and say, well, it should remain classified. And they say, sorry, John, threat to national security if we show you, so we're not going to show you. But in a lot of cases, you can appeal that, which I did. And if you put up a strong enough case, they will hopefully release that information to you. The appellate authority has now looked at the information and said, nope, we agree with the decision. All UAP videos and imagery, when it comes to video formats, are exempt. What we don't know is how much that is, but it likely encompasses everything that went to the UAP task force, at least from the U.S. Navy. We don't know at this point if there are any through the U.S. Air Force that they may tag UAP, but we know that the U.S. Air Force is not really, interested in UAP, seemingly. So we don't know how much is there. But I would argue that the U.S. Navy and their collection, so to speak, of UAP-related imagery would likely be the bulk of it. If the reason the Navy said is solid, which it sounds like the appellate authority agrees, what that will translate to is every other agency likely holding the same decision, because it all stems from the UAP Security Classification Guide. That essentially defines secrecy when it comes to the UAP or UFO topic. So that's a huge blow to those who are saying we're going through a disclosure process. That's a huge blow to thinking that congressional hearings will likely bring out stuff into the public realm. I know a lot of people are into this whistleblower protection language, yada, yada. There's a lot of speculation on that. I'll believe it when I see it. But essentially what this does is locks down, from a legal standpoint, them releasing anything, at least anytime soon. The fact that they've reviewed everything for me in this specific case means that legally, a lot of things can happen. But generally what that means is legally, it will be another 2 years before they are legally obligated to look at it again. Can Congress push for things and advocate for disclosure and let's release this to the public? Absolutely. Can Navy upper brass look at something and go, okay, well, you denied this through FOIA, but I'm going to go ahead and give the authority to release this. Let's say Scott Bray, hint, hint, that they look at this, or Ronald Moultrie. If you want to fulfill that promise that you gave of everybody during that hearing of transparency, and you said to the world that that's what you were looking forward to as long as it didn't threaten national security, take a look at this again. See if the appellate authority and the Navy made the right decision. Let me show you guys the letter just to get into a little bit more detail for those who are interested in this kind of stuff. Don't worry, that is a public address. I'm not worried about it being shown on screen. I'm going to only read a couple highlights here, but this will give you guys an idea of how this process works and how in-depth it can actually be. I'm not going to go through the arguments in my appeal because I already have a full video that has done that. So look in the description below. That will go ahead and give you a link to that if you're curious. Even though it was denied, recommend you do that, because I think I did put up an argument that we can use in the future to show congressional leadership, look, these are solid reasons why you shouldn't exempt everything. Those that fit into certain national security concerns, absolutely withhold it, redact it, do whatever you need to do. But we should be able to see the nuts and bolts imagery of whatever these UAP actually are. So this is from... Scroll down a little fast. The Office of the Judge Advocate General. This, in my other video, I go through my letter being sent to them. This is their decision. In your request, you sought, in addition to a fee waiver and expedited processing, quote, a copy of records, electronic or otherwise, of all videos with the designation of unidentified aerial phenomena, or UAP, that are archived by the U.S. Navy. You specified that your request included videos that were released officially on April 28, 2020 via the Naval Air Systems Command, public FOIA reading room, and a list of the videos that the IDA would release to you. I apologize for any delay that has occurred in processing your request. I love those apologies. They're in like every letter. The IDA issued its final disposition of your request on September 7th, 2022, denying your request. The IDA informed you that while it had located records responsive to your request, those videos would be fully withheld subject to FOIA Exemption B1. Again, national security. I didn't go over it, but IDA means Initial Denial Authority. In this specific case means the U.S. Navy. Under FOIA Exemption B1, federal agencies must withhold information that is properly and currently classified in the interest of national defense or foreign policy, as specifically authorized under the criteria established by executive order and implemented by regulations. Pursuant to Executive Order 13526, information regarding military plans, weapon systems, or operations are properly classified. If potentially responsive information qualifies as Exemption B1 information, there is no discretion regarding its release. When an agency relies on Exemption B1, the agency is afforded wide deference by the courts. Accordingly, to support citing this exemption, little proof or explanation is required beyond a plausible assertion that information is properly classified. Now, for any attorneys out there, I think I was one in a past life. I've dealt with this stuff for so long. Sadly, that is one of the more frustrating aspects of this, because even though I feel that I put up a solid argument on why this should be essentially declassified, you can see here that their court citation there, the Madison Project v. CIA, little proof or explanation is required beyond a plausible assertion that information is properly classified. The way that I translate that is the appellate authority says, okay, John's appealing the fact that this shouldn't remain classified. They pick up the phone, they call the IDA, which again, the U.S. Navy headquarters. They say, no, that we reviewed it, it's classified. Well, little proof is necessary, so the appellate authority says, okay, great, thanks, hangs up the phone, and that's all the proof that they need. Back to the letter. However, when invoking Exemption B1, denial authorities must comply with the FOIA's general requirement that agencies segregate and release non-exempt information. So again, even though the appellate authority is telling me, we hope that they're following the rules, the U.S. Navy does not have to prove that they are following the rules. Little proof is necessary. All they needed, meaning the appellate authority, all they needed from the Navy upper brass was to say they reviewed the information, followed the protocols, and it was classified. Pursuant to the FOIA, any reasonably segregable portion of a record shall be provided to any person requesting such record after deletion of the portions which are exempt under this subsection, 5 U.S.C. Section 552B. Under this provision, agencies and courts must differentiate among the contents of a document rather than treat it as an indivisible record for FOIA purposes. Agencies need not, however, disclose non-exempt information that is inextricably intertwined with exempt information. Information is deemed inextricably intertwined where disclosure would compromise the confidentiality of exempt information that is entitled to protection. Legal jargon to say they can actually overextend their reach on redactions and or withholdings just simply because they have concerns over releasing too much information where maybe we could essentially fill in the blanks. However, back to the letter. However, you are not entitled to disclosure if disclosure would produce only a few nuggets of non-intertwined, reasonably segregable information. To legal translation, I appeal and I demand that they release the or be, those words strewn throughout a page. They feel that would be few nuggets that would not be worthwhile. And I don't disagree with that part. To the extent that there may be bits of non-exempt information in the responsive documents, the IDA should provide information to illustrate that such information is either inextricably intertwined with the exempt information or the kinds of nuggets that are not required to be provided to requesters under the FOIA. Upon receiving your appeal, my office contacted the IDA to inquire as to the classification of the videos in question. The IDA informed my office that it had consulted with the Naval Intelligence Activity, the original classifying authority, or OCA, of the records responsive to your request. The OCA explained that the records responsive to your request were properly classified under Executive Order 13526 and remain classified. The OCA also stated that the records in question were reviewed by its subject matter experts, I wonder who those are, who determined that no segregation was possible. Here, as the Department of the Navy's appellate authority for FOIA appeals, I must defer to OCA's determination, as reported by the IDA, regarding the classification status of the videos in question related to national security. I am satisfied that the OCA's classification of the records responsive to your request satisfies the requirements under FOIA Exemption B1, as the videos at issue were reviewed for classification by the appropriate officials, and the videos cannot be segregated to supply information for you. Therefore, as the DON or Department of Navy Appellate Authority for FOIA Appeals, I have no authority to tell the OCA otherwise. Accordingly, your appeal is denied. You may seek judicial review of this decision by filing a complaint in the appropriate U.S. District Court. Signed, S.D. Schrock, Director of the General Litigation Division. Essentially what they're saying in these last paragraphs is, remember the callback, I'll call back to it, little proof is necessary. So they contacted the IDA, which then contacts the OCA, and they say, oh, it's classified, we reviewed it. And then it trickles back to the appellate authority, that's all that's needed. And so they deny it. So the appellate authority has no legal right to go back to them and go, well, maybe you guys made a mistake. Nope. Little proof is necessary. That's in case law. And that's it. That's the most frustrating aspect of all of this, is that in the end, the Department of the Navy won with their secrecy. Now, I mentioned that I would talk about the judicial review. I don't have an answer on what I'm going to do here. There's a lot of money involved in taking a government agency to court. There's a lot of time involved. And how do you fight something that is national security? So I would have to put up an argument about something that, beyond what I've already appealed, I would not have the knowledge about why exactly they are withholding that information. So the real reason that it would be a threat to national security if they were to release it is unknown to me. We just kind of have that broad stroke terminology that it is a threat to national security if they were to release it, and they have to protect X, Y, and Z, but we don't know specifically why they are withholding the information. So beyond what I've already put in my appeal, I am not sure if a judge would see it my way. Is there a possibility? Absolutely. Is it worth the financial gamble? I'm not sure. I really have no idea. This is just unfolding, as I said, in the last hour and a half or so. So I wanted to bring you guys the news just because, as you're all waiting for that UAP report, and we have no idea when it's going to drop, it may be in an hour for all I know. This is that level of secrecy that we are fighting. And not to beat the dead horse, but you've heard me talk about it on this channel before, that the secrecy is deepening and strengthening when it comes to UAP. And when you combine that with what I see is I'm hoping I'm wrong, but potentially a waning congressional interest. I know we were in midterms, and some people fought me on that sentiment when I posted it on Twitter. I think that the interest may be waning. I mean, look, I harp on the government a lot, but I also think that they can chew gum and walk at the same time. So just because they were going through midterms, if they can't ask questions about a congressionally mandated report, then we've got a bigger problem than most of us realize. So I think that we have to get a little bit, beyond that argument now that the midterms are over. And if we are not seeing that pressure for the UAP report, when you combine that waning interest along with this type of secrecy, where does that leave us? And I'm not sure. I don't want to say it's Condon 2.0 again, but we're not getting the results. We're not getting the pressure that I feel that pressure was on last year. We're not getting the same interest. Remember those sound bites that were kind of blasted all over the place? You had Fox News with Radcliffe, I think, was one of them. You had TMZ were running up to Congress people on the street saying, "What do you think of UFOs?" And, putting the camera in their face and getting some type of reaction from them. You had all those like sporadic videos that kept coming along and I would say fueling that interest, that momentum up until the June report. Now what happened here? And we don't know, but for me, it just appears to be that waning interest. Now, to play devil's advocate, we don't know if the ODNI that was in charge of that report, if they called Congress a week before the due date and said, "Hey, we're going to be late here. Really sorry. So we're going to have to extend the deadline here." And Congress goes, "All right, we really don't care. That's fine," or whatever they say. And it's all hunky-dory, which is maybe why we don't hear anything. And nobody's told the public, "Hey, by the way, ODNI is called." So as a result, the public is just going wild with different theories and cover-up allegations and this, that, and the other thing, when in reality, ODNI already fulfilled the requirement of contacting Congress and saying the report's going to be late. That's, in my opinion, the government is not on time all the time, so not really that big of a deal, potentially, to Congress. And so they just let it go. Meanwhile, the hashtag UFO Twitter and everybody involved in the conversation is all up in arms, when in reality it could have just been a extension of the deadline. We don't know. Maybe we'll find that out later. So it could go either way. I don't really know, but I wanted to throw that thought out there because I don't see a lot of people talking about it, that maybe this was just something that Congress expected and it's not that big of a deal. But at the end of the day, no one's talking. ODNI does not want to give any official statements out. The Congress side does not want to give any official statements out. I have tried on both fronts numerous times. Of course, anybody who does these stories will talk to people sometimes off the record. I can tell you that the consensus is no one really knows. There's a lot of theories of people posted on Twitter about the classified report being delivered already and so on and so forth. I don't see any signs of that, so I hope that those that are making the claims can back that up. But if it turns out that the report is not delivered, I hope you all keep those people accountable. There are times when we can guess and label it as such. I did some fun threads online just to kind of take guesses. I was guessing that the report would be on time. Obviously, that was wrong. But regardless, there's a time to have fun and guess, but there's another to say you have secret sources that are telling you things and asserting that to the public. So I hope you guys hold those people accountable, because some of those claims are getting pretty wild and crazy and silly. There was one even from the first report about a quote unquote leak from the classified version about alien technology and all this stuff that was on a pretty popular YouTube channel. Well, I got the classified version, even though a lot of it was redacted. There was no way that that was in that report. Nobody has ever disputed that classified version, even though it was heavily redacted. So obviously these leaks are silly and fabricated. So, sadly, though, no one is held accountable. So I hope that more people are done so. And that goes for me too, in case I wasn't clear on that. If you ever see me make a wild claim and it turns out to not be true and I don't admit it, please, by all means, hold me accountable. But it's primarily why I don't make wild claims or cite anonymous sources, because, well, when they're wrong, what are you going to do? Blame the anonymous guy? I don't play that game. So that's my update. That transparency is quickly vanishing, and those touting the disclosure line, sadly, are wildly wrong, at least from my vantage point, from every legal vantage point that I can offer you. But I look forward to any new information that drops. Don't worry, though. This does not mean that I'm done or going anywhere or I don't have cases open. Even though I can't access the videos, you know darn well I'm going after quite a bit more than that. So even though we might not get the fun visual eye candy, we may get some other stuff as well. As history has proven, we can definitely do that. We just got to try and be a little bit patient and be positive. So that's my advice to you. Thank you all for listening and watching. Please, if you can, give a thumbs up to the video. Spread the word. That's the biggest way you can help me. And if you want to help out the channel, if you feel like becoming a Patreon supporter or anything like that, there are ways to do that in the description below. That said, this is John Greenwald Jr. signing off, and we will see you next time.